No, the defense lawyer has to take care of it, my lord, at the trial.
Look at your owner of the auto rickshaw. What is his evidence?
Yes.
You don't even cross-examine him. Look at the
Certainly.
IMA report. Sir, ಇವೆಲ್ಲ ಬಿಡಬೇಕು ನೀವು. ಇಂಥವೆಲ್ಲ ಬಿಡಬೇಕು. ಗೊತ್ತಾಯ್ತಲ್ಲ? Look at your owner. He says you are the driver Azan that day. You had taken your auto rickshaw and it met with an accident and police seized and he executed an indemnity bond and got it back. And you deny
that
the
I am
accident.
not disputing, my lord.
And you deny the accident.
I am not disputing it, my lord.
ಮತ್ತೆ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಕ್ ಆಗೋದೇ ಇಲ್ಲ. ನೀವು ಆಕ್ಸಿಡೆಂಟೇ ಆಗಿಲ್ಲ, ಅವನ್ನೆಲ್ಲ ಕೆಳಗ್ ಬಿದ್ದಿದ್ ಸತ್ಯದಕ್ಕೆ ಅಂತ ಹೇಳ್ತೀರಿ. ನೀವ್ ಹೇಳೋ ಪಾಯಿಂಟ್ ಏನು ಅಂದ್ರೆ ದೇರ್ ಇಸ್ ನೋ ನೆಕ್ಸಸ್ ಬಿಟ್ವೀನ್ ದಿ ಡೆತ್ ಅಂಡ್ ದಟ್ ಆಕ್ಸಿಡೆಂಟ್ ಅಂತ ಏನ ಮಾಡ್ಬೇಕಲ್ಲ.
Because he was discharged from the hospital. That is
Shri Umesh Moolimani and learned HGP accused who suffered an order of conviction in CC number 136 of 2017 and sentenced as under, which was modified in criminal appeal number 10021/19 of 2019 has preferred this revision petition. First, next para. Facts in brief which are at most necessary for disposal of the revision petition are as under. Next para. A complaint came to be lodged by Srimati Lakshmamma, Sri Lakshmana on 11/8/2016 with Swaraba Police Station seeking action against the accused by contending that on 11/8/2016 at about 7:30 AM between Moody Doddikoppa - Hurlikoppa village on the government road, in front of land of Shivlingappa, complainant and others were proceeding in a passenger auto rickshaw bearing number KA 159538 as laborers. First, the driver of the auto rickshaw, bracketal accused, drove the same in a rash and negligent manner, and because of the said rash and negligent driving, driver of the auto rickshaw lost his control and the auto rickshaw fell into a ditch. First, because of the impact of the accident, ಅವನ ಹೆಸರೇನು ಇಂಜೂರ್ಡ್ ಹೆಸರು? All the passengers suffered. All the passengers suffered.
Hanmantappa, son of Guddappa,
and one among them, namely Hanmantappa, suffered grievous injuries and he was shifted to hospital for higher medical care. First, subsequently he was discharged from the hospital. First, despite the same because of the accidental injuries, he was not cured completely and ultimately he lost his life. First, opinion of the doctor who conducted the postmortem examination for cause of death is due to the shock as a result of injury to the cervical spinal cord and the brain. First, therefore, Lakshmana sought for action against the accused. First, police registered the case for the offences punishable under section 279, 337, 304A IPC and also under the provisions of section 3 and 181 of the Indian Motor Vehicles Act 1988. First, where is the driving license? Where is the driving license of your client?
No one.
ಮತ್ತೆ ಯಾಕೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಹಾಕಿ ರಿವಿಷನ್ ಮಾಡಿದ್ರಿ? A person who doesn't have the driving license drove the same. Is it not?
Yes. That's why
ನೀವು ಇಂಥದ್ರಲ್ಲೆಲ್ಲ ರಿವಿಷನ್ ಹಾಕ್ಬೇಕು. 2 ವರ್ಷ ಒಳಗೆ ಕಳಿಸ್ಬೇಕು. ಅವನ ಮಾಲೀಕನ್ಗೂ ಹಾಕ್ಬೇಕು. Allowing a person without driving license to take the vehicle on road, you have abetted ಅಂತ. ಆಗ ದಾರಿಗೆ ಬರ್ತಾರೆ. ಇಂಥವೇ ಮಾಡ್ಕೊಂಡಿರಿ. 10 ಜನನ್ ಕೂಡಿಸ್ಕೊಂಡು ಹೋಗ್ತದನಲ್ಲ, ನಾಚಿಕೆ ಆಗ್ಬೇಕು ಅವನ್ಗೆ ಒಂದ್ ಆಟೋ ರಿಕ್ಷಾದಲ್ಲಿ ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ ಇಲ್ದಲ್ನೆ. ವಾಟ್ ಆರ್ ದಿ ಕೆಪಾಸಿಟಿ?
It's only 3 men.
ಮತ್ತೆ 10 ಜನನ ಯಾಕೆ ತಗೊಂಡೋದ? ನಾಚಿಕೆ ಆಗೋದಿಲ್ವಾ ಅವನ್ಗೆ? ಎಡಗಡೆ ಪಕ್ಕ ಬಲಗಡೆ ಪಕ್ಕ ಇಬ್ಬಿಬ್ರು ಕೂತ್ಕೋತಾರೆ ಡ್ರೈವರ್ ಪಕ್ಕದಲ್ಲಿ. ಅದನ್ನ ಆಲ್ಟರ್ ಮಾಡಿಬಿಟ್ಟಿದ್ದೀರಿ ವೆಹಿಕಲ್ನ. ಹಿಂದ್ಗಡೆ 5 ಜನ, ಮುಂದ್ಗಡೆ 5 ಜನ ಕೂಡ್ಸಕ್ಕೆ. ಈ ಕಡೆ ಒಬ್ರು ರೋಡ್ ನೋಡೋರು, ಆ ಕಡೆ ಇನ್ನೊಬ್ರು ತಿರ್ಕೊಳ್ಳೋರು. ಸಿಮೆಂಟ್ ಹಾಕೋದು, ಇಲ್ಲ ಡೀಸೆಲ್ ಹಾಕೋದು, ಓಡಿಸೋದು. ಹೇಳೋರಿಲ್ಲ ಕೇಳೋರಿಲ್ಲ. ಇದ್ರ ಮೇಲೆ ದೊಡ್ಡದಾಗಿ ಟೇಪ್ ರೆಕಾರ್ಡರ್ ಹಾಕೋದು, ಪಿಕ್ಚರ್ ಹಾಡ್ ಕೇಳ್ಕೊಂಡು ಹೋಗೋದು. ಇವ್ನು ಎಡಕ್ಕೆ ತಿರುಗಿಸ್ತು ಅಂತ ನಾನು ಬಲಕ್ಕೆ ತಿರುಗಿಸ್ತು ಅಂತಾನೆ. ಅವ್ನು ಯಾವ ಕಡೆ ತಿರುಗಿಸ್ಬೇಕು? ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ ಇಲ್ಲ, ಏನಿಲ್ಲ. ಅಂಡ್ ಯು ವಾಂಟ್ ಟು ಆರ್ಗ್ಯೂ ಆನ್ ಆಲ್ ದೀಸ್ ಥಿಂಗ್ಸ್? ಐ ಡೋಂಟ್ ನೋ. ಮತ್ತೆ ಏನಾಯ್ತಮ್ಮ? 3 and 181 of the Indian Motor Vehicles Act and conducted a detailed investigation and filed charge sheet. Presence of the accused was secured and charges were framed. Accused pleaded not guilty, therefore trial was held. Next para. In order to establish the case of the prosecution, in all (18) witnesses were examined. Among them, PW 1, 2, 3, PW 1 to 8, 1 to 9 are the injured eyewitnesses who have also traveled in the very same auto rickshaw. First, prosecution also placed on record 29 documents comprising of the complaint, postmortem report, further statements, wound certificates of the injured witnesses, further statements, FIR, additional complaint, requisition, etc. Accused statement as contemplated under section 313 CRPC was recorded on conclusion of the recording of prosecution evidence. First, accused has denied all the incriminatory circumstances, including the accident. First, thereafter, the trial judge heard the parties and convicted the accused as aforesaid. Being aggrieved by the same, accused preferred an appeal for the district court in criminal appeal number so and so. Learned judge in the first appellate court, after securing the records, modified the conviction and the sentence as referred to supra. First, next para. Being further aggrieved by the same, accused is before this court. Next para. Shri Umesh Mulimani, learned counsel for the revision petitioner, reiterating the grounds set in the revision petition, vehemently contended that both the courts have not properly appreciated the case of the prosecution and wrongly recorded the order of conviction for the offence under section 304 IPC and sought for allowing the revision petition. Next para. Per contra, learned HGP supports the impugned judgments. First, next para. Having heard the parties, this court perused the matter law on record meticulously. On such perusal of the matter law on record, the accident in question has been properly established by the prosecution by placing cogent and convincing evidence on record, including the testimony of the injured eyewitnesses. First, admittedly, accused revision petitioner did not possess any driving license to drive the auto rickshaw. Owner of the auto rickshaw has been examined as a prosecution witness, and he has admitted that the police has seized the auto rickshaw on account of the accident, and he has got released the auto rickshaw by executing the indemnity bond. First, next para. This witness is not even cross-examined by the accused. First, fact remains that as on the date of the accident, it was the accused who was driving the auto rickshaw without a driving license, and because of his negligence, auto fell into a ditch, and all the inmates of the auto rickshaw, who are 10 in number, got injured, and one among them is the Hanmantappa, who got severe injury to the cervical spine and ultimately lost his life as per the PM report. First, next para. Taking note of these aspects of the matter, and also in the absence of any contra evidence placed on record, learned trial magistrate convicted the accused for the aforesaid offences. First, being not satisfied with the order of the learned trial magistrate, accused preferred an appeal before the district court, and learned judge in the first appellate court considered the matter on record and modified the conviction order and modified the sentence as well. First, next para. Taking note of the fact that actually 338 ಹಾಕಬೇಕು, ಬೇರೆ ಇಂಜೂರ್ಡ್ ಇದ್ದಾರೆ, ನೀವೇನು ಮಾಡಿಲ್ಲ, ಇನ್ನು ಅದ್ರ ಮೇಲೆ ನೀವು ಕೇಳ್ತಿರಲ್ಲ. ಬೇರೆ ಇಂಜೂರ್ಡ್ಗೆ 279 ಅಟ್ರಾಕ್ ಆಗ್ತಿರಲ್ಲ, ಸ್ಟೇಟ್ ರಿವಿಷನ್ ಹಾಕ್ರೆ ಅಲೋ ಮಾಡ್ಬೇಕದು. 304A ಮರ್ಜ್ ಆಗುತ್ತೆ. ವಾಟ್ ಅಬೌಟ್ ಅದರ್ ಇಂಜೂರ್ಡ್? 337, 338 ಗ್ರೀವಿಯಸ್ ಇಂಜುರಿನೂ ಇದೆ ಒಬ್ಬನಿಗೆ, ಅದರಲ್ಲಿ ವುಂಡ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇದೆ. ಏನ್ ಮುಳ್ಳಿಮನಿ ನೀವು? ಐ ನೆವರ್ ಎಕ್ಸ್ಪೆಕ್ಟೆಡ್ ದಟ್ ಯು ವಿಲ್ ಆರ್ಗ್ಯೂ ಇನ್ ದಿಸ್ ಫ್ಯಾಷನ್. ನೋ ಸಾರಿ, ಇರ್ಲಿ ಬಿಡಿ.
Only
ಇರ್ಲಿ
one.
ಬಿಡಿ.
My lord, it is when I filed the
ತಪ್ಪಾಗಿದೆ ನೋಡಿ ಎಲ್ಲನೂ, ಎಲ್ಲ ತಪ್ಪಾಗಿದೆ.
that I cannot argue, my lord.
ನೋ ನೀವು ಅದನ್ನ ಮಾಡಿ ಅಂತ ಹೇಳಿಲ್ಲ ನಾನು. ಫೇರ್ ಆಗಿರ್ಬೇಕಲ್ಲ ಕೋರ್ಟ್ಗೆ.
Only one question is
ಅಲ್ಲ ಮಿಸ್ಟರ್ ಮುಲಿಮನಿ, ರಿವಿಷನ್ ಹಾಕ್ಬೇಕು, ಹಾಕಿದ್ದೀನಿ. ನಮ್ದು ಇಷ್ಟೇ ಕೇಸ್ ಇರೋದು. ಇನ್ಫ್ಯಾಕ್ಟ್ ಮೈ ಕ್ಲೈಂಟ್ ಈಸ್ ಎಂಟೈಟಲ್ಡ್ ಫಾರ್ ದಿ ಹೈಯರ್ ಪನಿಷ್ಮೆಂಟ್, ಇಲ್ಲಿಗೆ ರೆಸ್ಟ್ ದಿ ಕೇಸ್ ಅಂದ್ರೆ ನಾವೇನೋ ಮಾಡ್ಕೋತಿದ್ವಿ. ಅದ್ರ ಬದಲು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಕ್ ಹೋಗ್ತೀರಿ.
Only one point, my lord. Opportunity was not there.
ಇನ್ನೇನು ಹೇಳ್ಬೇಡಿ. ನಾನು ಆಮೇಲೆ ನಾನು ಸೋಮೋಟೋ ತಗೊಂಡ್ಬಿಡ್ತೀನಿ. ಸೋಮೋಟೋ ಪವರ್ ಎಕ್ಸರ್ಸೈಸ್ ಮಾಡ್ತೀನಿ. 397 ಸೂಪರ್ವೈಸರಿ ಜೂರಿಸ್ಡಿಕ್ಷನ್ ಅವ್ರು ಆಗ್ತಾ ಇದ್ರೆ ಬೇಕಾಗಿಲ್ಲ. ನಾನು ಸುಮ್ಮನೆ ಬಿಡಿ ಅಲ್ಲಿಗೆ ಸಾಕು. ಅದೆಲ್ಲ ನೋಡಿ, ಅವರು ಚಾರ್ಜ್ ಶೀಟ್ ತಪ್ಪಾಗಿ ಹಾಕಿದ್ದಾನೆ. ಮ್ಯಾಜಿಸ್ಟ್ರೇಟು ಅಷ್ಟೇ. ಬೇರೆ ಇಂಜೂರ್ಡ್ ಇದ್ದಾರೆ. ಪಟ್ಟಾಪ್ಲೇಟ್ ಕೋರ್ಟ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜಿ ನೋಡ್ಬೇಡವಾ ಅದನ್ನ?
No comment on that.
ಅಷ್ಟೇ ಕಾಮೆಂಟ್ ಅಲ್ಲ ನೋಡಿ ಬೇರೆ ಯಾರೋ.
It is evident on yes, my lord.
ಅಲ್ಲ ಮುಲಿಮನಿ ಅವರೇ ಕೇಳಿ. If a novice in a new entrant in the bar were to make some submissions, well, I understand. He may not know ಅಂತ. ತಾವು ಹಿರಿಯರು, ಅನುಭವಸ್ಥರು, ಈ ಕಡೆನೂ ಇದ್ದವರು, ಆ ಕಡೆ ಇದ್ದೀರಿ, ಎಲ್ಲ ತಿಳ್ಕೊಬೇಕು ಅಂತ ಪ್ರಕರಣ ಬಂದಾಗ. ಇಲ್ಲ ಏನೋ ಆಗಿದೆ, ಅದನ್ನ ನಾನೇನು ಹೇಳಕ್ ಹೋಗಲ್ಲ. ಎಸ್, ಏನಾಯ್ತಮ್ಮ? ಆಯ್ತಾ? ಆಸ್ ವೆಲ್ ಫಸ್ಟ್ ನೆಕ್ಸ್ಟ್ ಪರ. ಇನ್ ಫ್ಯಾಕ್ಟ್ ದಿ ಸ್ಟೇಟ್ ಶುಡ್ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ revision petition against the order of the learned judge in the first appellate court, as there are enough materials which would not only attract the offence under section 279 IPC but also under section 337 IPC, 338 IPC. First, next para. Be it what it may, since the state has not chosen to file any revision, this court perused the matter on record in the light of the argument that is put forth on behalf of the revision petitioner, and is of the considered opinion that the injured eyewitnesses having supported the case of the prosecution and post-mortem report clearly shows that the death of the Hanmantappa is on account of this injury to the cervical spine